Hey, everybody. Ben Wittes here. Welcome to this week's Trump Trials and Tribulations. We kind of have an all-star panel today, just out of court. We have Anna Bauer in South Florida. From Washington, D.C., we have the great Marty Lederman. From Austin, Texas, first time on Trump Trials and Tribulations for them both, we have Lee Kovarsky from the University of Texas Law School. And of course, from an undisclosed location, I'm Ben Wittes. And we're going to get right into it because there has been a lot going on, and a lot of it has been going on today. Anna Bauer, you were in an all-day hearing in Fort Pierce, Florida, with Judge Eileen Cannon, some amici, and special counsel Jack Smith's team and Trump's team. What were they talking about? And tell us about what happened.
Yeah, it was a lot, Ben. There was a lot of substance to this hearing. So this particular hearing is the first of 3 days of hearings that Judge Cannon has set in Fort Pierce over the next several days. Today, we focused on the appointments clause of the Constitution. And then next week, we will also focus on some more of Trump's motions to dismiss, but then also some other discrete issues like, for example, listeners might remember that the special counsel's office has requested a modification of Trump's bond conditions to basically restrict him from talking in certain ways about law enforcement who are on the case. But today, the focus was, like I said, the appointments clause of the Constitution and the question of whether or not Jack Smith was lawfully appointed as special counsel. Trump, as a part of his pretrial motions, had filed a motion to dismiss, claiming that Jack Smith was not properly appointed and in violation of the appointments clause of the Constitution. The gist of it, and there's a few like moving parts here, Ben, because there are non-parties, people who are amicus parties, that's what they're referred to, who ended up joining or intervening and filing briefs, and they have their own discrete arguments. But the gist of Trump's argument has also evolved in light of some of those arguments that were made by the non-parties. But the kind of basic premise that they're arguing is that under the appointments clause of the Constitution, basically there are these things, this like category of people who are officers of the United States. There are principal officers who need to be nominated by the president and then confirmed on the advice and consent of the Senate. And then there are inferior officers who Congress can delegate basically authority to, for the principal officers to appoint these inferior officers. And so there will be these vesting statutes in which Congress says, okay, yes, this principal officer, the president, heads of departments of federal agencies are allowed to appoint various people into these inferior officer positions. And then there's also a third category, which is just people who are regular old employees, and the appointments clause of the Constitution actually does not apply to people who are just, employees. So those are the three categories that are important. And the reason that these categories are important is because basically Trump's argument is that Jack Smith obviously was not appointed by President Biden and then confirmed by the Senate. However, what did happen is that Attorney General Merrick Garland appointed Jack Smith to this position. There was this appointment order in which he referenced a number of different statutes under the United States Code, and Trump saying none of those statutes actually are proper vesting statutes that really give the Attorney General any authority to appoint a special counsel like Jack Smith, who is someone who was basically a private citizen outside of government who was then brought in to do this independent investigation. And so therefore, the result, Trump says, is that the indictment has to be thrown out because Jack Smith was acting in a way that was outside of the law, because to begin with, Merrick Garland did not have a statutory authority to appoint him. So that is kind of we'll get into the weeds of it a little bit more.
We'll get into the weeds, but before we get into the merits of the question, I want to understand, this is a matter on which, there is a controlling Supreme Court opinion. There's some pretty clear statutory law. How does it take all day?
Well, one of the reasons that it takes all day, and I want Marty to jump in if there's anything
no.
that I should.
That is something you should never say. When we will go to Marty in a moment, but if you invite him to leap in and seize control, you'll never get it back.
Okay, well, look, the reason that it takes all day is because this is Judge Eileen Cannon.
No, Ben, I am to you as Jack Smith is to Merrick Garland. I'm subject to your supervision.
But so the reason that it took all day is because this is Judge Eileen Cannon that we're talking about. And keep in mind, Ben, this is only half of this motion to dismiss. There is a whole other argument that we're going to have a hearing on Monday that deals with not the appointments clause, but appropriations and funding of the special counsel's office. But today she set an entire day's hearing in which in the morning session, we heard just from the government and from the defense counsel, their arguments. And then in the afternoon session, there were 3 non-parties who were allowed to come in and make oral argument. And so that is the reason why it took all day, is because, and again, that's a very unusual move for a district court judge. It's not quite so unusual for appellate court judges to allow non-parties to make argument, but it certainly was something that I have not seen at the trial court level. So in a criminal case, nonetheless.
All right, so let's briefly run through what everybody argued. I assume Trump's lawyers argued first.
Mm-hmm. Yeah. So
and what is their current position?
Right. So it was very interesting, Ben, from coming out of our experience in New York, seeing Todd Blanche and Emil Bovee, who are Trump's defense attorneys, both in the New York case and then also in the classified documents case, seeing them in Florida again, which I've seen them many times before, but going from seeing them in kind of, in the thick of trial, doing cross-examination and direct and closing arguments. And then here they are in Florida arguing this motion that felt much more like a kind of appellate oral argument that they were making. And Emil Bovee argued on behalf of Trump. Again, he focused on the arguments that I was just making. But one of the things that became clear is that Trump, because in the beginning of this motion to dismiss, they initially were saying that out of those 3 categories I mentioned, that Jack Smith was at best an employee of the Justice Department and was not an officer of the United States. But they quickly realized that actually that does not really work for their argument, because then that would mean that the appropriations clause of the Constitution, the appointments clause of the Constitution does not even really apply to what they were arguing. And so then they changed to arguing that in fact, the special counsel is a principal officer of the United States who requires Senate confirmation. They focused especially on that argument. So they were kind of making a number of arguments about, how much oversight, how much independence the special counsel had from the Attorney General's office. But then the other main thing that this is what Judge Cannon really wanted to focus on a lot, is their statutory authority argument. Like I said, there's a number of statutes that Attorney General Garland cited when he appointed Jack Smith as the special counsel. And the two main ones that canon and that the parties were mostly focused on are 28 USC 515 and 28 USC 533. And there's like a number of statutory interpretation. Again, I don't want to get too in the weeds with it, but there are a number of statutory interpretation issues that Judge Cannon was particularly focused on. The gist of it is that Trump's team was saying that neither of the plain text of these statutes actually creates any kind of power for Garland to appoint a special counsel. 515 refers to, for example, special assistant attorneys and special, what am I forgetting? Special, Marty, help me out here. Special assistant attorneys and special assistants and special attorneys. And then the 533 refers to the power of the Attorney General to appoint officials to prosecute crimes against the United States.
Yeah,
so
it's canon. I don't know. I think 533 is kind of a blockbuster on the Justice Department side here, but that's just me. It says the Attorney General can appoint people to do investigations.
Well, you would think so, Ben. However, here is the issue that Judge Cannon had with 533. Again, it uses the specific language of giving the Attorney General the power to appoint officials to prosecute crimes against the United States. The Constitution uses the term officers of the United States. And so Judge Cannon was very concerned with this kind of what she saw as something that might be a statutory, a textual difference between what the meaning of an official is and then what an officer is. DOJ was arguing that the reason that official was used, and one of the non-parties also argued this as well, official encompasses both employees of the United States and inferior officers of the United States. And it's just a more capacious way of, encompassing both of those things without having to say employees and officers. But Trump's team was saying, no, if Congress meant that this allowed, for the power of the Attorney General to appoint inferior officers, then they would have just said officers. They wouldn't have said officials. And so that was kind of the main, and Judge Cannon kept coming back to that statutory interpretation focus over and over and over again. So that was kind of the main thing. The other thing that came up a lot throughout the hearing is this question of whether the Nixon case, there is a graph in that case that was related to a subpoena that was issued to President Nixon in relation to the investigation of the Watergate scandal. But basically, there's a graph in that Supreme Court opinion in which the Supreme Court says, attorney generals Congress has given attorney generals the power to appoint an independent counsel under and then list statutes like 533 and 515. And Judge Cannon was very focused on this question of whether or not that is binding precedent. Is it persuasive precedent? Is it dicta, or is it a holding? So what is she supposed to do with this paragraph in the Nixon case? Of course, Trump's team was arguing, it's maybe hardly even dicta. The parties didn't argue it in that case, that kind of thing. So there was no real grappling with the statutory text here. The Supreme Court just kind of assumed or presupposed that there was this authority. It wasn't something that was really dealt with. DOJ, of course, said, no, you basically are bound by the Nixon case here. It's very clear.
I seldom agree with Warren Burger about anything or say anything nice about him, but on this matter, the man had a point. All right, I'm going to bring Marty in a second, but before we do, spend a moment on the afternoon, because we had not one, not two, but three amici taking up an entire afternoon of your time. Did they add anything to the conversation that took place in the morning between DOJ and the sepulchral Emile Bovy, or was it merely repetitious of arguments that the party were making?
Well, so I would say that Matthew Seligman, who is one of the parties who argued in opposition to Trump's motion to dismiss, many of his arguments largely supported DOJ's argument and they were very similar to DOJ's arguments. Also, the attorney who represented Edwin Meese, the former attorney general, and then also Calabresi, the law professor academic who has written about this subject. Ben, you may remember during the Mueller investigation, Calabresi wrote about this kind of issue a lot. And then also, I believe that Citizens United Foundation was another party that was represented by Jean Scherer. Correct me if I'm messing up the pronunciation. Scherer, is that how you pronounce it? Anyone know? Okay. Well, anyway.
Sure. Yeah.
Thank you, Marty. And so the argument there, again, very much was kind of reflected or was in support of many of the same arguments that Trump's team was making, especially since they transitioned from arguing that the special counsel was at best an employee to then arguing that, no, he's a principal officer who needs to be confirmed by the Senate. But the one that was really distinct and that I want to bring Marty in to talk a little bit more about was Josh Blackman's argument. He represents Seth Tillman and the Landmark Legal Foundation. Josh Blackman and Seth Tillman are two academics who have written a lot, attorneys and academics who have written a lot about the officer of the United States language in the Constitution and what it means to be an officer of the United States. And the argument there is that actually Jack Smith is not a principal officer of the United States. He is an employee because the special counsel's office is not a continuing position, and therefore he still was acting outside of the scope of his authority because he's been acting in a way that he's vested with all of these powers of a U.S. attorney, and so therefore, even though he should be considered an employee, he was still acting unlawfully through conducting this investigation. But Marty, please jump in and elaborate.
Actually, no, don't jump in. Let me tee up. Let me tee this up. First of all, for those of you who do not know, Marty is an actual real live expert on the appointments clause. So let's start with who has been at OLC at least 3 different times. And one of the things that OLC spends a lot of time working on is appointments clause issues. So is it fair to say, Marty, that you, I think the technical term is a shitload, that you have a shitload of experience with the appointments clause?
I have more than is healthy for any human being, many years. But that said, Ben, I actually think that the way this case was briefed by former President Trump, he really didn't make any appointments clause arguments, except maybe very much in passing. He sort of did a Me Too on the Meese Calabresi argument about there being a principal officer. In his briefs, they are almost entirely devoted to the statutory question of whether Congress has given the Attorney General the authority to do this. Before I start, Ben, in fairness to your viewers and listeners, I just a full disclosure, I was working in the Department of Justice Office of Legal Counsel at the time that Attorney General Garland appointed this special counsel. Take that for what you will. I will not be revealing any internal or non-public information, but for what it's worth. But I've also blogged.
Can I just say, though, that I think it is a reasonable inference for somebody to assume that OLC would have consulted with the Attorney General, would have consulted along the way with Jack Smith on a number of issues. And I'm not asking you to comment on that.
I'm certainly not going to speak to the latter. as to the former, the an appointment of this sort is the sort of thing that OLC would not invariably be consulted about, but obviously the questions going back, one of the things I want to point out is that this practice is age old and has been thoroughly vetted within the Department of Justice for many decades. So it is fair to assume, Ben, that Attorney General Garland was not kind of winging it. Let's put it that way. Fair to assume that much. But I'm not going to.
So can I? Let me ask you about each of the three issues in turn, right?
Well, I'm just going to. But I wanted to say, apart from my OLC work, when acting Attorney General Rod Rosenstein appointed Bob Mueller as a special counsel, I did write extensively about these questions on just security. And I'm just going to I just put in the chat the first of those, and it links to the others for readers who are interested in, have nothing better to do this weekend because it's 100 degrees here or something like that. So So Ben, I think the principal issue, and it sounded from what Anna said, the principal topic of discussion today is really not a constitutional question about the Appointments Clause at all, but one about the Attorney General's statutory authority. There are two Appointments Clause issues, one of which is an actual issue, although it's, as you pointed out, been resolved and pretty clear. The other, what we're calling the Josh Blackman, Seth Barrett Tillman argument, is just misguided in several different ways. It's not even a real question. If they were right, it would only make the appointment here even more legal, not less. So those two are constitutional issues, but they were raised in the first instance by the amici. I believe Trump has said that he agrees with the Meese-Calabresi argument about principal officer, but it's not one that he really focuses on in his briefs. And it sounded, Anna, like that it was the subject of some discussion today, though.
Yeah, so when Bovee stood up, he said, I want to focus on two things. The first is the statutory authority arguments, and then the second is the Meese argument about principal officers. Right. Like I said, that's something that evolved from their first brief, in which they said, at best, Jack Smith is an employee, and Cannon kind of made them clarify. So you're saying that this is what you agree with Meese, and they said, yeah.
So Ben, well, however you want to tee it up is fine with me. I can explain to the readers what the Appointments Clause is, or we can save that till the end and just start with.
Well, let's, since it sounds like the body of the conversation was about the statutory issue, let's start with that. It seems to me 533 says, and I don't have the text of it in front of me, but it says something to the effect of, the Attorney General shall have the power to hire people to do investigations at his discretion. I forget the exact language, but why isn't 533 wholly and completely an answer to this problem?
Here, I'm gonna put it in the text. Tell me if that comes through to you. Okay. Is it wholly and completely an answer? It is, but Ben, I think you don't even need to get there. So let me situate this under with respect to two other statutes, both of which have a very, very long pedigree going back into the 19th century when the Justice Department was created. First is 28 U.S.C. 509. So this is what your listeners and viewers should know. Section 509 confers upon the Attorney General all the functions of other officers of DOJ and all employees and agencies of DOJ. So Attorney General Garland has the statutory authority to perform all of the functions, with a couple of exceptions not relevant here, of the Department of Justice, including he could have been the lead on this prosecution himself. Okay, that's the starter. It doesn't have to be a U.S. attorney. It doesn't have to be the criminal division or the tax division or whatever it is. The Attorney General can prosecute cases. 510 in turn says that the Attorney General may from time to time make such provisions as he considers appropriate, authorizing the performance by any other officer, employee, or agency of DOJ of any AG function. So the first statute gives him the authority to do everything within the Justice Department, well, this function anyway. And the second gives him the authority to delegate that power to any employee or officer. 509 and 510 then, I think, make this pretty easy as a matter of statutory construction. The government has relied as well on 515 and 533. 515, just briefly, 515B assumes that there will be attorneys specially appointed, this is A, by the Attorney General, and specially retained under the authority of DOJ as special assistants or special attorneys, as Anna quoted. So 515 reflects what 509 and 510, and more importantly, more than a century of history demonstrates, which is that Congress and the executive branch have understood that Congress has conferred upon the Attorney General the authority to perform prosecutorial and investigative functions and to delegate those functions to others, and importantly, to hire people from outside the department to become part of the department. When I was hired, when Michael Dreeben was hired as Deputy Solicitor General, or when Sri Srinivasan, who was on the DC Circuit case that dealt with this, he pointed out he was hired by the Attorney General to be in the Solicitor General's office. Those appointments and those offices were all created under this array of statutes. So the statute, and then you get to 533, Ben, and yes, the language is pretty damn simple. The AG may appoint officials to detect and prosecute crimes against the United States.
Detect being an archaic word for investigate, right?
Find, yeah, to find them.
Right,
Yeah.
like notice, figure out what the crimes are.
There's an argument. That's a later statute. I believe it wasn't cited by Attorney General Reno, if memory serves, in the regulations for the special counsel, so, and the like. But the point is, and it's in the section of Title 28 that involves the FBI and the like. But here's the important point. For well over 100 years, attorneys general have been assigning special prosecutions of particular delicacy or political sensitivity or what have you to counsel who were not in the department before the investigation started, going back to the Grant and Garfield administrations and Archie Cox and Leon Jaworski, and then including Ed Meese in 1987 when he was the attorney general. He created even when the special counsel,
even when the independent counsel statute existed,
was there,
he gave them a concurrent appointment.
Correct. He created a regulatory office of the special counsel and appointed Lawrence Walsh to head it. So he's now, I guess he's saying that he violated the law back in 1987 when he was attorney general. Now, but
all right, so
this is all to say, but here's the key point. In the Nixon tapes case, when it was Leon Jaworski, the court said, as you pointed out, Ben, unequivocally, that this array of statutes gave the attorney general the authority to do precisely this. Now, it is true that no party disputed that fact in Nixon, okay? But the reason they didn't dispute it, the reason Richard Nixon, who had every incentive to dispute it, didn't dispute it is it was a terrible argument to say that the AG didn't have this authority. No one thought that. Nixon threw up a lot of arguments. This wasn't one of them. And so all the justices and all the parties, including the president who was fighting Jaworski, did not make this argument because it's such a weak argument. So
right, and I will just add that in the sainted Antonin Scalia's dissent in Morrison, which on the other issue here is the controlling opinion, he specifically talks about this as the necessary mechanism, right? That if you're, what are his objections to the independent counsel statute? That it's appointed by a 3-judge panel, that it's not immediately fireable by the attorney general or the president, right? And these are, if you take that statute or that opinion as the guide to what the attorney general does have to do for appointments clause purposes, all of those things were done here, down to that the authorizing reg was promulgated by the attorney general and can be amended by the attorney general. All right, so I want to ask you before we turn to New York,
sorry, Ben. Ben, I just wanted to, on the statutory point, I find it hard to imagine that Judge Cannon will actually hold that there's no statutory authority. She may not be comfortable with it. This case, in the Mueller case, one of the Mueller cases, Dabney Friedrich in the District of Columbia District, was unpersuaded that the statutes were a great fit for this kind of practice, but she acknowledged that the practice existed and, more importantly, thought that Nixon was determinative of it. And of course, that's what the DC Circuit said as well. She's not going to say that the court hasn't decided it in Nixon, even if she writes 30 pages saying that the Supreme Court should revisit this statutory question. I find it almost inconceivable that she will rule that Congress has not authorized the Attorney General to do this. So do you want to discuss the two constitutional questions, or should
we? Yeah. So let's talk about, because the two constitutional arguments are flatly at odds with one another, right? One is saying he's a principal officer and therefore he has to be Senate confirmed, which is actually inconsistent with controlling precedent. The other argument says he's an employee and thus can't have all these powers. What gives here?
Okay, so let me start with what I'll call the Mies Calabresi argument, which is that he's a principal officer. So for those of you, this is where we get into the law nerd stuff. The Appointments Clause of Article 2 of the Constitution says the following. It says that if you are an officer, the default rule is that you have to be appointed by the president by and with the advice and consent of the Senate. That default rule has come to be known as the rule for principal officers. So think of heads of departments, the Attorney General, him or herself, Secretary of the Treasury, the members of the Fed and the like. There's an exception in the Appointments Clause, which is that with respect to what the clause calls inferior officers, Congress can provide for them to be appointed in either that way, by President and the Senate, or three other ways, by a court of law, by the president alone, or by a head of a department. Here, of course, the head of a department did make the appointment. So the argument would have to be this person, Jack Smith, this office is not an inferior office. It's a principal office, and therefore requires President and Senate involvement for the appointment. Ben is absolutely correct that the court rejected that in Morrison versus Olson with respect to a special counsel who was far more independent and had less supervision and control by the Attorney General than does Special Counsel Smith. That was Alexia Morrison, pursuant to the statute Congress created. Morrison held that Alexia Morrison was an inferior officer and therefore could be appointed by, in that case, a court of law, but certainly by a head of a department. Because of that, it follows a fortiori, that is to say, it can't be the case that if Morrison is correct, which Judge Cannon has to assume it is, that Jack Smith isn't likewise, at most, an inferior officer, in which case his appointment was perfectly permissible under the Appointments Clause because it was done by the head of a department. So this too, like the statutory question, is just governed by Supreme Court precedent.
I would just like to add, it was just an interesting moment during the Josh Blackman argument, which Josh Blackman is one of the folks who's arguing that he's an employee, not an inferior officer, as was determined in Morrison. But Josh Blackman specifically invited Judge Cannon to basically overturn Morrison versus Olson, a Supreme Court precedent on this issue. So that was a very interesting moment. And then James Pierce, in rebuttal, stood up and said, Your Honor, I'm not entirely sure if I heard correctly, but I believe that one of the amici invited you to overturn the Supreme Court's precedent in Morrison versus Olson. So just wanted to note that because that was explicitly, invited by at least one of the parties. Although, again, whether or not a district court judge can overturn a Supreme Court precedent is obviously not something that's really in question, because
if Josh Blackman said that, it's characteristic of the sort of legal argumentation that he's become renowned for. So it is not going to happen. And if it did happen, Judge Cannon would be very quickly reversed. She's not going to hold that he's a principal officer. Not only because Morrison is governing, but because to overrule Morrison would also be to overrule centuries of practice that would call into question just an enormously long history of appointments like this. Not only I would have been a principal officer and my appointment was unlawful. That would have been true of countless DOJ officials throughout time, and many officials appointed by heads of departments throughout the executive branch, throughout our
You're
history.
a principal officer to us, Marty.
No, I'm not, Ben. I'm subject to your direction. That's the terms of this. So anyway, so then we get to this third argument, which is the Seth Barrett Tillman, Josh Blackman argument, which is that he's not an officer at all. He's what's called an employee. And now at this point on Friday afternoon, your viewers are like, what? What's that? Well, yes. If you're not an officer at all, now, this is an argument that Trump hasn't made, so it's waived. It's not in the case. Why she's allowing them to argue about it is somewhat befuddling. B, and more importantly, here's the irony. One of those posts in that list that I linked to, that I wrote about Mueller, I actually agree. I think there's a very strong case that the regulatory special counsel is an employee and not an officer at all. But that's not the position of the Department of Justice. And the reason is basically the reason that Josh Blackman gives, which is that this is someone who's appointed. It's not an office that stays in place in perpetuity. It's the appointment of an individual to a particular function for a discrete period. In any event, it's a close question whether he is an officer, but the courts are going to hold that he's an officer. Here's the big thing, though. If he were an employee, if Josh Blackman and Seth Tillman were right, then the constitutional question gets even easier, because then the appointments clause doesn't apply. There is no constitutionally mandated method by which employees have to be appointed. So instead, they come
Otherwise, the honors program couldn't exist.
Right. So they instead come up with this other argument, which is that if you are a mere employee, you cannot be vested with significant authority of this kind. But they cite nothing for that proposition, and there's no support for it. The statute allows the Attorney General to delegate even significant authority to employees, people who are not officers, and that's what's been going on. So in the cases historically in which the court has held that a position is an employee position, not an officer position, that has been in cases in which the person was exercising significant authority, and the holding is, therefore, because they're an employee, the appointments clause doesn't apply, and there's no constitutional problem. So if Josh Blackman were actually correct, which I'm kind of sympathetic to the argument, but it won't prevail, what it would mean is that the constitutional problem would go away even more easily than the other one. So this too is so the upshot of these three arguments is none of them is very serious, right? None of them has any chance of prevailing in any court of appeals, and I would venture before the Supreme Court.
I will
leave it at that.
I'm an interloper to this particular question, but do your viewers understand how crazy it is that Judge Cannon gave amici time to argue these legal questions in the district court?
Well, we have mentioned this, the eccentricity of that and the unusual quality of it several times, but it bears mention again. It's super unusual. The only times I have ever seen it done are when first of all, sometimes when the Justice Department refuses to defend something, the courts will assign somebody to do it, or when there's some kind of concern about whether a given argument is going to be made, the court will sometimes assign somebody to make it, but usually that's at an appellate court level. I've seen it done at the district court level, just very, very rarely. And all right, so all of this brings me back to Anna. What the heck is Judge Cannon doing? She's given argument time in this highly eccentric fashion to not one, not two, but three amici. She's entertaining arguments that I'm glad Marty agrees with me are just not serious. And she's spending just a lot of energy on this. What's your takeaway about what she's doing? Is it just using up time, or is she going to dismiss the case on this basis? What do you think is happening here?
So it was a little bit hard to tell today because she was very, being very Judge Cannon, where it's kind of a lot of not really seeing the forest through the trees. There were so many idiosyncratic things that she was focused on that it felt a little bit like when you're in law school and you have an issue spotter and like you're just trying to make as many arguments as you can and spot as many potential issues as you can. And because you're just trying to get all the points that you can by raising all of the issues, you kind of fail to see maybe sometimes the broader picture. And that's not really the way that I've seen a lot of judges operate. There's kind of a little bit more of, focusing on the big picture things and especially at the district court level where, you're just trying to move a case along. So it is a little bit unusual, but it's also not necessarily inconsistent with the reporting on how Judge Cannon handles a lot of her cases. But in terms of what my overall takeaways were from today, she's taking these arguments very seriously. But she, at the same time, I think ultimately seemed to be leaning towards some skepticism about Trump's argument that these charges should be dismissed on the grounds that Special Counsel Smith was unlawfully appointed. There were times when she really pushed back on Emil Bovey at certain arguments that he was making. For example, he suggested that basically if Special Counsel Smith is allowed to do this, then it means that any attorney general could appoint a shadow government of sorts that just has this kind of unbridled, that was the term he used, shadow government, unbridled authority without, the confirmation from the Senate to basically investigate whatever and do whatever. And that would not be, in line with the Constitution. And he was expressing all of these concerns about the consequences of what would happen if Judge Cannon kind of let these charges go forward under Jack Smith. And she said, well, I don't know if it's fair to cast aspersions like that, especially about in this case, I don't think that it's that there's basically that you basically can't assume that that's what's going on here. There were other times that she expressed skepticism as well. But at the same time, she, again, being very Judge Cannon, would ask these questions over and over again to all the parties that seemed like, she's really focusing on these statutory interpretation arguments. She doesn't like the way that maybe some of the terms, official, I mentioned that. She's not so sure that she likes the fact that special assistant or special attorney is used in different ways throughout the U.S. Code, or that official is used throughout the U.S. Code in different ways. She asked over and over again if there were other examples of vesting statutes or statutes that give this kind of appointment power that use the term official instead of officer. So she's clearly taking these Trump arguments very seriously. She also was focusing on, which we haven't talked as much about, the kind of level of independence of the special counsel. At the very end, for example, she was really pushing James Pierce, the attorney who was arguing on behalf of the special counsel, to say whether or not the special counsel, whether or not Merrick Garland had approved the indictment that was sought by Jack Smith. He had to say over and over again to her, I'm not trying to hide anything, but I don't want to get into the internal deliberations of the Justice Department, because she continued to press on, was there approval of the indictment? What is the level of supervision by Merrick Garland of the special counsel's office? And so all of that relates to this question, I think, of whether or not she's going to determine if the special counsel is a principal officer or an inferior officer. All of that said, I still think that what she might do is what I'm now calling a canon, in which she writes like a 20-page opinion in which she says, oh, I'm so sympathetic to Trump's arguments. They make a lot of good arguments. They say this is like such a good point, et cetera, et cetera. And then in the very last paragraph say, despite all of this, and despite the fact that I would hold otherwise, there is this in the Nixon case. And so therefore I'm going to hold that the motion is denied. And so that's the kind of the feeling that I get coming out of this hearing that she might do, but who knows?
No, I will just say, if I were Jack Smith, I would be very much hoping to lose at the district court level on this, because it's a sure winner at the 11th Circuit. And this is a good, clean way to get something in front of the 11th Circuit, not on mandamus.
Well, and also, Ben, check back with me on Monday and Tuesday, because I'll be back in court and we will have more motions to dismiss, some attorney-client privilege stuff, maybe even a Franks hearing. So just stay tuned, because
it's going to be all action. All right, let's turn to New York, where the former president is already convicted, already found guilty. I guess he will be formally convicted when sentence is pronounced in a couple weeks. I know that a whole lot of people out there, and you may be one of them, have been thinking, how is this going to be handled on appeal? What are the good arguments? What are the lousy arguments? Is this going to stand up? And there has been, as you've undoubtedly seen, a great deal of certainty in Trump world that this is dead on arrival at any competent court of appeals. And so we did a lawfare thing for you. We asked Lee to take a look at the appellate issues and write a piece, and it's a good, long, meaty piece about the appellate issues. We will share it in the chat, and to kind of walk through them and figure out which ones might have legs, which ones clearly do not. So Lee, give us an overview. How substantial do you think Trump's chances on appeal are? What are the garbage arguments, and what are the arguments that may actually require some adjudication?
I'll say that, first of all, thanks for having me, Ben, and everybody else. So I'll say at the outset that I don't know that there were more errors in this case than any other case. Sort of the Trumpist etherealism of like, that goes on around the claims
there
here.
Are 300 reversible errors.
Yeah, I don't really, I don't see any of that. That being said, there's like mistakes in every case, right? And if you look hard enough, you can find one, and then you're stuck arguing about whether it's sufficiently harmful that, the conviction's overturned on appeal, and Trump has better than average lawyers, than the average criminal defendant who's convicted in New York. And so for that reason, I think he's probably got slightly above average likelihood of getting a reversal. That's not to say that it's above or even near 50%. the problem with the discourse, as it were, is that I think that Trump World and the aligned legal coverage likes to focus on things that do effective double duty as like media talking points. So stuff about how the trial's rigged, and so you're focusing on the $15 contribution that Justice Merchan made to Biden or something like that. That is not a real appellate issue. And it's probably underplaying the more boring, more complicated, more legalistic issues that are, while they might not be winners, are at least non-trivial.
Well, we are not above giving the boring issues their due. So let's do that. What are the issues that you think have the best chance of success, however boring and wonky they may be?
So everyone should understand that the basic structure of the charge by the end and the conviction is based on the following framework. Trump was found to have conspired to promote his candidacy through unlawful means, and then filed paperwork to cover that up. I know people are like, what is he convicted of? He's convicted of that. Now, Justice Merchan instructs the jury that in order to find that there was what I'm going to call 15152 conspiracy, that's the conspiracy to unlawfully promote his candidacy, that there has to be one of three unlawful means. Either a FICA violation, a federal campaign finance violation, other falsified documentation, or a state tax law violation. Now, those are the unlawful means in play. Now, crucially, Justice Merchan also says, look, you have to unanimously find that there were unlawful means, but you don't have to agree unanimously on which unlawful means or combination thereof it was. And I think in that move lurks the most appellate potential for a couple of different reasons. Reason number one, and I think it's probably this argument's okay, is that they did have to be found unanimously, each of the unlawful means. And so, either under state law, and I doubt Trump would win there. I don't think the New York State Court is going to find that that you needed to find which unlawful means the conspiracy was conducted through unanimously. But maybe if the Supreme Court wants to get involved, that's an area that they might want to constitutionalize. A second way it matters is if the Supreme Court says, actually, one of those unlawful means or more was an error. In other words, shouldn't have given the instruction the way it was given, right? For example, assume the Supreme Court says that the instruction on the federal campaign finance violation was given incorrectly. So the conviction can't be bottomed on that. And if you subtract out the FICA violation from the menu of unlawful means, you can't be certain whether the jury would have still convicted without that unlawful means being available. And so I think that's another way in which the unlawful means instruction could come into play down the road. Again, I don't know that how strong these arguments are, but I certainly think they're non-trivial. I think they're the best ones. I think a lot of these other arguments, for example, that Justice Merchan, was biased, or that there's some sort of successful selective prosecution claim lurking here, and even some of the prejudicial stuff about the idea that some of Stormy Daniels' testimony is prejudicial. I think those are pretty weak arguments.
So if I were writing the brief for Trump, I would focus on the inclusion of tax law stuff that the conduct of which post-dated the supposed conspiracy, on kind of the theory that you just articulated, that, hey, wait a minute, it can't be an unlawful means to have done something later, and you don't know that one juror didn't convict purely on that basis. So therefore, how would, if you were Emile Bovy, and you were constructing the appeal, presumably you would have some noise up front about, the political nature of the prosecution and the prejudicial and the blah, blah, blah. But then you'd focus the actual argument on some version of the argument that you just articulated. Is it FICA? Is it the tax stuff that I mentioned? Is it both? How do you hone down that argument into its strongest form if you're thinking on behalf of Trump?
Yeah, Bovy's a good lawyer. He's not a clown. He knows what the bullshit is. Unfortunately, he's got co-counsel Donald Trump, who might force him to put some of the more blustery stuff at the front.
Well, he's not going to read the briefs.
Yeah, so the way I would approach it if I were Bovy is I would march through each of the unlawful means individually and say why the instruction as to that unlawful means shouldn't have been given. So the FICA instruction was unlawful because state criminal punishment for federal campaign finance violations is preempted. Or the appropriate willfulness instruction wasn't given under FICA. So FICA's out for that reason. Then go to the unlawful means instruction involving the state tax violation and say, well, the state tax violation instruction shouldn't have been given because the state tax violation postdated the 2016 election. So how could it promote the candidacy? Now, there are answers to that, but I'm just going through why Bovy would structure it the way it is. And then I would move on to the point that if you take out either one of those as invalid, then you've got to reverse, because you can't be certain that if that unlawful means were unavailable to the jury would have still convicted. And then separately, I would argue that regardless how you feel about that set of arguments, the jury needed to be unanimous as to the unlawful means, because what the unlawful means were should be treated as an element of the offense, either under New York law.
Although there's some pretty clear precedent that says exactly the opposite of that, right?
Right. That's why I made the remark that I don't think that it's plausible to argue that under New York law, unlawful means required instruction that the jury needed to be unanimous as to what the means were. And if the Supreme Court wants to get involved, maybe it dramatically expands this case, Shad v. Arizona, which would be the mechanism for constitutionalizing the issue.
So the Supreme Court conveniently issued an opinion today that involved jury unanimity. What does it have any implications for the current case and or for the president's case, or is it just coincidence that will give rise to some news on Fox News, but doesn't some commentary in the right-wing media ecosystem, but that won't actually make a difference in court?
So I think it will definitely be, fodder for sort of Trump-aligned bullshit in the broader media ecosystem. I also think it's possible that it serves as like kind of window dressing and briefing somewhere. That being said, the issue that was decided in that case, Erlanger is the name of it, isn't really what's at issue when you're talking about unlawful means. Basically, in Erlanger, we're talking about the rule of what's called Apprendi, and the Apprendi rule is that any fact that increases the available punishment maximum has to be found by a jury beyond a reasonable doubt. And so people in Trump world are going to say, like what the unlawful means were has to be found beyond a reasonable doubt. It's a fact that increased the maximum available punishment. I mean, no, right? The fact that increased the amount of available punishment was that there were unlawful means, right? And the question at issue is, are you going to extend the requirement that there be unanimity that there were unlawful means to unanimity as to which combination of unlawful means there were?
All right. Before we go to audience questions, we need to touch base with the case in DC and the case in Fulton County. Anna, I saw on Slack you and Quinta trading incredulity about the latest interview given by one Nathan Wade. Bring us up to date on Fulton County and the latest, I think the technical term is shenanigans there.
Shenanigans indeed. So Nathan Wade, as many listeners are aware, has been on a media tour of sorts since he left the Fulton County prosecutor's office. He's been on CNN, he's been on ABC, he's been on all these different news stations, except the Lawfare Podcast. And as we always say on this podcast, if you're gonna jeopardize the case against the current presidential frontrunner for the Republican presidential nomination and the former president, you should.
How dare you do it anywhere but the Lawfare Podcast?
On the Lawfare Podcast. Instead, what Nathan Wade did was he went on the Daily Show and did a kind of, it was very odd and jarring. It was the comedian and actor Marlon Wayans, who is in character as someone asking him questions that were highly, I won't even repeat some of the questions. I found them to be just really gross and disrespectful. They were, alluding to a lot of things about Nathan Wade's romantic relationship with Fani Willis, making kind of references and innuendos towards their sexual relationship. Nathan Wade, instead of, he acted in a way that he was just laughing at the jokes. It was very odd. And again, shenanigans is a good term for it. I truly just do not I'm kind of speechless at this point, to be honest. I have said again and again, I do not understand why he is doing this or why he thinks that this is at all appropriate of someone who was formerly yes, a contract attorney, but also a public servant and a prosecutor.
And an officer of the court. An
officer of the court who should be held to an incredibly high standard. And this, it was just a really, really odd appearance. And I can't even fathom why he thought that it was a good idea. Other than that, though, Ben, we do have some substantive movement in Fulton County in the appeal that is going on related to that relationship between Nathan Wade and Fani Willis. Keep in mind that previously Fani Willis's office made a somewhat unusual motion in the Court of Appeals after the Court of Appeals decided to take up that issue. It was they styled it as a motion to dismiss the appeal as improvidently granted. Not something that a lot of Georgia appellate attorneys that I've spoken to have really even seen before. Many of the appellate attorneys I spoke to said they did not even think that procedurally it was a type of motion that the Court of Appeals was even kind of allowed to entertain, basically. But essentially what Fani Willis's office said was the three-judge panel that decided to grant this appeal, which is a different panel than the one that ultimately gets the appeal, made a mistake. They shouldn't have granted the hearing of the appeal. And then Trump's filed his response this week, again, making the argument that I just referenced, which is basically that the Court of Appeals, this is not even a procedural thing that they can do, which is dismiss an appeal as improvidently granted after a panel of the appeals court already granted the appeal. And then it's now been assigned to a panel and that kind of thing. So that is the latest in terms of filings in the Fulton County case. That case, again, is still, like the DC case, stayed, except for some of the defendants whose cases are not stayed, but there has not been a whole lot of movement in those other cases. So we will see what the Court of Appeals does with this motion to dismiss.
All right. And of course, we've had no movement in the DC case, which remains stayed because of the Supreme Court. But Marty, both Marty and Lee, we've had a lot of hand-wringing from prominent people, including in the op-ed pages of the New York Times, about the delay that the Supreme Court has created. We've had a lot of it expressed on these live streams as well. I have two questions about this. The first is, how do you guys understand, Marty first and then Lee, the Supreme Court's behavior here? And then I'm going to throw out, after you guys address that, a possible approach for Jack Smith when the Supreme Court finally does rule. Marty and then Lee.
So I am definitely a contrarian here, I guess, at least among the folks that you were referring to, Ben. I don't think there's anything particularly out of the ordinary in the way the Supreme Court, or surprising in the way the Supreme Court has handled the immunity case. In fact, I think every other case I can think of involving an interlocutory appeal in a criminal case, but for the Nixon tapes case, the court has always set it for the following term. That would have been the norm, would be to hear it next year, but they moved it up to this year. This is just a very unusual situation. Unfortunately, forget presidents. People running for federal office are not ordinarily being subject to a prosecution during a campaign season. It's not unheard of, but almost unheard of. It happened to Ted Stevens because he wanted it to happen. He wanted to be vindicated before he went for re-election. But there are very few cases. And quite honestly, thinking about what might be going on within the Supreme Court, so they did set it with an expectation they would decide it before July 4th. They will decide it before July 4th. I think it's probably unlikely they decide it in their next sitting, decision day, which is Wednesday or Thursday, because the debate is Thursday night, but probably Friday, June 28th, or Monday, July 1st or July 2nd, I would suspect. And they're handling it the way I've thought they would handle it all along. I filed an amicus brief in the case. I think and I hope that they will hold that there's no immunity for Donald Trump here, but I do think, and I'm not surprised, that several of the justices, maybe most of them, maybe all of them, are concerned about future prosecutions of presidents, particularly when juries are asked to assess a president's mens rea, where he or she claims to have thought or intended X, and the jury finds, no, you're lying. And therefore, they want to be very careful about at least articulating possible constitutional constraints, maybe not immunity, but constraints about the application of certain broad statutes to official presidential conduct. So I think writing that opinion, even if they rule against Trump, which I've been predicting they will, takes time, and there will be separate opinions. I mean, I think it's unlikely that John Roberts will hold all 9 justices around one opinion. And even if he can, that's going to take several weeks of negotiating to get to. And therefore, it's not surprising at all to me that this would take the time that it's taken. And I think in the view of the court, It's completely appropriate. I don't think, remember, the case is about allegations that a government official, the President of the United States, used his authority as a government official to try to improperly affect an election, which he shouldn't have been doing. I don't think the court or the Justice Department thinks it ought to be deciding this case or even deciding the timing of the decision based on the November election. It shouldn't be trying to affect the election. The real date of concern is January 20th in case Trump is elected, because at that point, if the case is still ongoing or pending, the best case scenario is it just stops dead for 4 years while he's in office. It just has to stop. So January 20th is a real deadline of sorts, possibly. So I'm not surprised at all. I think we're going to see a decision either next Friday or a week from today or a week from Monday, probably. And I'm somewhat hopeful that the court will hold that the prosecution can go forward without more. But it's possible that they will say that certain parts of the indictment are constitutionally questionable and need to be pruned or adjudicated. I think that's what most people think. I'm in the minority on that, but obviously it's a possibility.
Lee?
Yeah, I mean, I think that there's a sizable coalition of contrarians then. I mean, that Marty articulated what's my view, both in terms of what I predict and also what I think is kind of normatively desirable. I mean, I wrote something in the New York Times saying that, look, given that the court has decided to take this case, they need to write a rule that is attentive to the fact that there's likely to be retributive prosecutions against future ex-presidents. And, you know, if you listened to oral argument, it's clear that the court isn't starting from a place of near unanimity. So, you know, one of two things are going to take time. Either, either the chief is going to herd cats, or, there's a bunch of people writing a bunch of different opinions. And the court should take the time to get it right. I mean, this is going to be a longstanding structural problem, and if they prescribe the wrong medicine, it's going to cause a lot of damage for a lot of people. And I'll say, I also agree with Marty. I think Trump's going to lose. And I think he's going to lose, fairly decisively. Not lose in the sense of like 9-0, but I think that there's pretty clearly 5 justices, at least if they don't move from where they were in oral argument, who are just not playing this game at all. And one of the things that Amy Coney Barrett showed interest in towards the end of oral argument was how to structure what happens next. In other words, like how to write an opinion that gives some guidance about how the lower courts are supposed to process any immunity rule. Is there going to be an interlocutory appeal from, any decision in the district court that runs against Trump? Even if there's unanimity on, the underlying substantive question about, what the immunity standard is, there certainly is not going to be, it's certainly not going to be easy to get to unanimity or even, a strong majority on the question of how to structure that process. And it seems like you really want the court to lavish some time on working that out, because if they don't, then Trump's going to be able to gum up the works if when that's underspecified. So I think it's both totally unsurprising that it's taking this long, and actually it's not nearly as bad as people think.
All right, so I want to bounce off you both, and Anna, if you have thoughts on this, my action plan for Jack Smith. There are going to be 2 rulings that have potential implications. One is the Fisher case, which deals with 1512C and affects potentially 2 of the charges. The second is the immunity case. On the theory that both Lee and Marty are correct, that there's not going to be a broad immunity that nukes the indictment. We're going to be talking about individual paragraphs and individual allegations, particularly, say, with respect to firing the Attorney General and appointing Jeff Clark as acting Attorney General, right? I mean, there are certain fact patterns that are are arguably within the scope of official conduct, some of them more clearly than others. And if you grant a broad immunity or even a qualified immunity, you get into the question of interlocutory appeals before before you can go to trial. So my question is, these two rulings come out in the next 2 weeks, and should we expect Jack Smith to file a superseding indictment, potentially dropping the two 1512C counts and simply crossing out several paragraphs of the indictment that raise the factual issues most vulnerable, most contestably official under whatever the Supreme Court rules? So knock out 5 pages of the indictment and go forward with 2 charges instead of 4. Lee first, and then Marty. Am I fantasizing?
I don't think they're going to file a superseding indictment. There's lots of, I think that's a cause for a lot of delay, which they're concerned about. I also think the premise of the question isn't, I don't think actually the court is going to knock out much of anything in the indictment. John Roberts seemed like he had nothing but contempt for the official act standard, and the Jeff Clark stuff is the only official act stuff, that's even arguably official act stuff. And if they don't even get the official act standard, what could get cut out? That being said, let's assume some stuff is in play or whatever. Like I said, I don't think they'll file a superseding indictment. I just think they'll say okay, you can't, this conduct that is immunized can't be the basis for a finding of criminal liability, but it can go to other issues like proof of intent and stuff like that.
Marty, what do you think?
So Ben, let me just quickly on your reference to the Fisher case, which is the second case you mentioned, and that's about the statutory question. There, I think, although I think the court ought to rule for the government, I think that the odds are much less propitious for the government in that case. And so if the court does cut back on many of the January 6th cases in the Fisher case, which will be an administrative burden for sure for the DDC and the prosecutor in DDC. The special counsel argues that even if the government loses Fisher, those charges in the Trump indictment are not affected because they come within what ought to be what the court rules anyway, that those are covered. It obviously
documents only, right?
What's that?
Documents only, right?
Yeah, because of the false elector.
But it totally matters how they rule.
Yeah, exactly. So Fisher, obviously, if Fisher cuts out that charge, it's just gone. Lee's better than I am at what the mechanism is, a superseding indictment, or Judge Chutkan just says that's a dead letter now. We're not going forward to the jury with that one. But if not, they would keep it. Now, if the court were to rule, contrary to what Lee and I are predicting or hoping, that certain of the allegations in the indictment are or might be either immune or I think more likely constitutionally questionable on the merits. I think it depends. I don't know what special counsel Smith would do in that case and what the equities would be. It might depend on how confident he is that he would preserve those on, in the proceedings below. I think that my sense, and I don't say this with any inside information at all, is that the most important part of the indictment for him to preserve is not the creation of the false electoral slates, but the things that they were created for, which is the efforts to try to get state officials to change the electoral count from those states, without which the false electoral slates were kind of never going to go very far, realistically. So I would be very surprised if the Supreme Court were to say that there's any question about going forward with those charges in the indictment. And if they don't, if they bless those, for all I know, that's enough. That's the heart of the case.
Right.
And it could go forward with that. If they say that there has to be some adjudication as to whether those allegations can go forward, your guess is as good as mine. And I wouldn't say anything publicly anyway.
Can I ask a question, Dan, or do you want to own the the end here, and we need to wrap up.
Well, I want to get through some audience questions.
All right, yeah, ignore.
All right, so Mark Durbin starts with a question that I want to treat with some sensitivity. I'm going to read it, but I'm also going to challenge the premise of it a little bit. Did you know that Eileen Cannon's immediate family, mother and grandfather, have been at the forefront of Cuban exile community efforts to free Cuba from communist rule for more than 60 years, and that Trump's South Florida campaign operatives like Roger Stone woo that critical Florida voting bloc with an "I alone can fix it" promise of a free Cuba regime change? Can we consider those factors, along with her FedSoc amplified deep state distrust, as her motivations for rejecting her district chief judge's recusal, urging, and her ongoing deliberate trial delay? So I respect the question. I don't know the factual premise of that question to be correct. I'm not saying the question is incorrect factually, but the answer did you know part is no, I don't know. I also don't want to speculate about Judge Cannon's motives. I think her performance has been objectively deficient. Her errors have all gone in a single direction. And I think people are entitled to make judgments about that and to look for whatever explanations they want. I don't spend time on people's motives as a general matter. I read the work, and the work strikes me as deficient and in certain instances, flamboyantly, obviously wrong. And so I don't know. I have not looked into her soul. I don't know the woman. I don't want to pretend to know what relationship it has to her ideology, to her professional ambition, to her any hypothetical relationship with Cuban exile communities. I don't want to speculate about that. I just want to evaluate it on the basis that she's doing an objectively terrible job. Do any of you have contrary or?
I'd like to interject. There's no way I'm getting anywhere close to, talking about questioning Judge Cannon's motives. But I don't know who Mr. Durbin is, but I'm really thrilled that the question was asked about like this vast Cuban emigre community conspiracy, just in order to say the following: in light of the great Donald Sutherland's passing yesterday, to tout, make sure your viewers and your readers and your listeners go back and look at some of his amazing work in Invasion of the Body Snatchers as the original Hawkeye Pearson mash, but most importantly, his extraordinary role in Oliver Stone's somewhat, over the top JFK, where he plays this. He has this amazing cameo as this sort of dark, secret former spook, spinning out this vast conspiracy involving Cuba. And it's one of his greatest performances. And I'm going to put in the chat a link to a wonderful little tribute written by Alfred Soto, who's a terrific academic based in Florida, about Donald Sutherland and about that scene in particular. So just use this question as a jumping off for our Donald Sutherland love here.
Yeah, but I gotta correct you on one point. His Invasion of the Body Snatchers was the remake.
Of course it is, yes, of Don Siegel's 1956 Invasion of the Body.
And the 1956 movie, which I am convinced was the inspiration for Ionesco's Rhinoceros, because it's exactly the same story, is...
I thought you were going to say it's the inspiration for the Lawfare blog, but maybe...
Oh, it is that too, of course. All right, so 2 questions from anonymous attendee. If the Supreme Court overturns the New York the New York conviction because of non-unanimity among the jurors, does that flip a whole lot of older cases? Lee, explain the rules for when the Supreme Court later concludes that a different case than yours is deficient.
So if the Supreme Court says you need to be unanimous as to unlawful means, then there's just like a whole lot of standard crimes that are defined by reference to unlawful means, like, or, for example, larceny, depriving theft, i.e. like depriving someone of their property by unlawful means or something. There are just so many crimes that are defined that way where you don't have to be unanimous as to what the unlawful means were for the crime to happen, that if the Supreme Court were to really get in there and say, no, you need to be unanimous as to unlawful means, it would be extraordinarily disruptive to the finality of criminal convictions, which is something that, in lots of other texts, the Supreme Court cares lots and lots and lots about. And honestly, I don't think that there's a scalpel sharp enough for the Supreme Court to make the cuts that it would need to make in order to avoid just severing that artery with blood everywhere. That went to a dark place, sorry.
All right. Well, severing an artery with blood everywhere is presumptively an unlawful means.
But Lee, I will say, I hesitate to say this, but yes, that's right. And I don't think the court will say something like that. But as you suggested earlier, the stronger argument for Trump appears to be, to my mind, that some of the possible, at least one of the three possible unlawful means might be legally deficient, even if there were unanimity, right? And we don't know that the jury depended on the other ones. And in particular, you mentioned the the FICA preemption question. Yep. Let's say the U.S. Supreme Court holds that one of the three prongs is preempted as a matter of law. I don't know what that means. I also don't know whether that was adequately preserved at the jury instruction stage. But I do think it's a thornier question if they rule not just on the unanimity question, but that one of the three means is legally insufficient.
All right. Roberts asks, Ben recently called the classified documents case as involving heart attack level felonies. Given that the classified documents case involves national security, are there any additional protections to keep the case going forward if Trump becomes president? Thank you. I love questions that I can answer with a single word: no. And I'm not actually, it's very simple. There are no protections at the federal level if Trump becomes president. We've never experienced anything like that. And the national security nature of the case doesn't situate it differently from any of the other federal case. Anonymous attendee asks, can you give us a hint of what a fatal error by Judge Cannon might look like? Well, I'll give you two. One is granting this motion that Anna spent a good chunk of today talking about. That would go up on a non-mandamus regular appeal because it would involve dismissing the case. And I'm certain that if that were to happen, Jack Smith would, among other things, raise to the 11th Circuit's attention that she has not been an entirely fair arbiter of these matters. Josh asks, any word on E. Jean Carroll's request to have her $5 million appeal expedited? I don't know anything about this. Do any of you guys?
Do not.
All right, we got nothing for you on that, Josh. And then finally, last question from anonymous attendee: is Judge Cannon in the tank for Trump, or is she just in so far over her head that she feels the need to keep doing this stuff so that she doesn't have to get into the heart of the case? I spent more than 35 years at NSA, and this is mind-boggling and insane. At some point, does she not have to get in to the actual case? If Biden wins, can she drag it out forever? So look, again, I don't want to talk about her motives, but she's clearly behaving in a dilatory fashion. And I think the answer is no, she cannot drag it out forever. There are deadlines associated with filing motions, and she can methodically work her way through each motion, but eventually you run out of that stuff. I also think Jack Smith will eventually take her up and will find some issue to bring her up on a writ of mandamus. I know not fast enough for a lot of people in the audience, but he's going to do it when he thinks he can win. And remember, the 11th Circuit, it's not the 5th Circuit. It's not like it's not a crazy conservative court, but it's a conservative court. And so he's going to bring it up when he's ready to do it on a basis in which he's confident he can win and get her removed from the case. And that will not be on an election-based time schedule. It will not be on audience frustration level time schedule. I will just say to employee, 35-year anonymous attendee employee of the National Security Agency, the federal courts do not work like a federal agency, right? They work, there is nobody more powerful in the world than the district judge in your case. And this is something that people who have not spent time in district courts, people think district courts are the lowest level, the Supreme Court is where all the power is. And that's true in some gestalt meta sense, but it's not true if you have litigation in front of that district court judge. The district court judge is the scariest, most powerful person in the world. And that is what Jack Smith is dealing with now. And there's no analog to that in a federal agency, which is much more vertically integrated. We are going to leave it there. Lee Kovarsky, Marty Lederman, thank you both for joining us. You guys, we do this every week. You should join us anytime you like. We'll always be delighted to have you anytime. Anna Bauer, you're a great American. And Anna is having to spend the weekend in Fort Pierce, Florida.
It might be cooler than it is here. Might be cooler.
It is all for you. She is there for you.
I have good news for everyone who's worried about me complaining about being in Fort Pierce for the weekend. I got upgraded to a beachfront room in the hotel that I'm staying in. So
it's the beachfront room in your palatial mansion,
in my
which defies time and space.
Folks, can I ask Anna one question before we cut out?
Absolutely.
Are you guys going to have access? Is it going to be the transcript from today's hearing going to be public anytime soon?
So unfortunately, in the Southern District of Florida, I am not aware of people getting transcripts any sooner than like a week after the hearing. For some reason, even the rush transcripts tend to go quite slow. Maybe it's a few days. I don't know, but it seems like it's not going to be like some other jurisdictions where we very often can get it like, the next day or something like that. So
but eventually.
But we will have a dispatch from Anna Bauer that will go through what happened today in some detail. That'll be tomorrow. Folks, for those of you who are watching on YouTube, saw me answering people's questions, wanted to join the conversation and couldn't because you're not here in the inner circle, you can be. Become a material supporter of Lawfare. Remember, it's a federal offense to give material support to designated foreign terrorist organizations, but it is a virtue to give material support to Lawfare. You can do that and become one of the people who gets their questions answered at lawfaremedia.org/support. Join our material support program. Signing off until next week.